Good afternoon, everyone. Thank you for joining us. We have several important topics to cover today, so I will go ahead and get started now by going over the agenda and introducing our panelists. First up, we have Elizabeth Heifetz from our New York City office. Liz will be updating us today on breaking news with respect to H-1B petitions. Following Liz, we have our former host, Kristen Smith, joining us today from our Syracuse office. Kristen will be covering leaves of absence as a reasonable accommodation. And last, but certainly not least, we have our other former webinar host, Adam Master-Leo, joining us today. Adam will be discussing new independent contractor reporting requirements, as well as the increase that some of you may heard about to the New York State unemployment insurance benefit. Okay, I will now turn it over to Liz. Liz?
All right. Should be thinking. Thanks, Carrie. Good afternoon, everyone. So as Carrie mentioned, wanted to take some time today to talk about what happened over the weekend, implications of this new update to the employment immigration world. So to those employers, clients, anyone who has any kind of affiliation with employees on H-1Bs or thinking about it, this is going to be pertinent to that. This situation is still developing. Things change hourly in the state. The directive is extremely broad, and so a lot of it is going to be subject to interpretations and case-by-case basis. So I will always kind of recommend, if you have a case-specific question, please reach out, and we'll see what we can do to kind of go through that and navigate through that. But what happened? On Friday, September 19th, President Trump issued a proclamation that essentially said anybody who wants to file an H-1B petition must also include a $100,000 supplemental fee. That's all that it said. And they said that this would be in place for 12 months with the possibility of an extension. Just, to have a base of how drastic this is. Normally, when you file an H-1B petition, it can cost a couple $1,000s, whether it's a cap or a cap exempt institution. It's very, de minimis compared to 100,000 fee that they're now, implementing. But as you can imagine, once this came out on Friday, all chaos kind of ensued because people didn't understand what it was referring to. So let's fast forward to Saturday afternoon. Customs and Border Protection issued a clarification. They issued a memo that essentially said this would not impact any people who already have existing H-1Bs. It's not going to impact those that have already filed H-1Bs, and will only affect the new petitions that are being filed after midnight on September 21st, and only those for individuals who are currently outside of the US. This still leaves a lot of room for interpretation because we're, figuring out, they don't mention change of status. They don't mention change of employer petition. They don't mention extensions. All of these things are going to be kind of figured out over the next several weeks as, we're going to hear updates from USCIS and as cases get filed, and we'll kind of see what is considered new, as they define it. If you have a approved H-1B petition, but that has not been activated yet, and you have to go to the consulate to activate it, is that considered a new petition? These are the questions that we're going to be answering over the next few weeks. Because it doesn't impact existing H-1B visa holders, we'll say, yes, the CBP has clarified you can travel, you can continue to work, re-enter the US, but please make sure that everybody brings their documentation. H-1B approval notices, the original copy, the original notice on that hard piece of paper, no copies, recent pay statements, at least 3 of them, employment verification letters that can confirm your ongoing employment with them. If you must travel, that's what you should do. People have been admitted and it's been fine, but we generally recommend if you can avoid international travel, please do so until at least the scope of the restrictions is a little bit more clear. It's supposed to be fine for H-1B visa holders, but in this climate, we would rather be safe than sorry. So that's kind of the advice we want to issue on that front. Also, the memo clarified that if you do file a new petition for employees, that this $100,000 fee will only apply for that new petition. Once you file an extension for that initial petition or a change of status, you don't need to repay that $100,000. That will only happen that first time. Again, we'll figure out. We suspect there's likely going to be litigation in the next couple of weeks as well. This could all change. It could all, vary. We don't know. At the moment, that is all that we essentially know right now. Like I mentioned, USAS did not address expressly at all if this is going to extend to extensions or if someone is changing an employer who already has H-1B status. So until there is additional clarification, there is always a risk that the government is going to take a more broad stance on kind of what this means. And we're just waiting. And there is no distinction also between cap and non-cap. So for instance, if you're a higher education institution or nonprofit research organization, normally before this came out, there are exemptions for them. So they don't need to pay certain fees. This does not distinguish anything between the two of them. It applies equally across the board. And whatever happens, we'll kind of figure out in the next couple of weeks, but there is no distinction between those two. And then to make the story even more interesting, this morning, we got yet another alert to kind of be aware of called Project Firewall. And this is essentially an enforcement initiative that is going to investigate employers for abuse of the H-1B visa process. It sounds kind of scary, but here's how you prepare for it, essentially. This is not things that employers, that this can be new to employers. For instance, as a general rule, you should be already conducting, internal audits. If you have H-1B employees, having the public access files on record in the office, in paper copy, or, some electronic version, having labor condition applications that are signed, ensuring that H-1B workers are being paid the appropriate prevailing wage that is listed on the labor condition application, making sure that the job description aligns with the job title, with the role, with the education, to make sure everything kind of checks off every box. Reviewing hiring practices, recruitment practices, just to make sure that everyone is compliant and that U.S. workers aren't being disadvantaged as the regulations state. When you bring on an H-1B employee, there's certain protocols that take place. So as a general rule, please make sure to have all of these things on file, because yes, DHS could have come to employers' offices anytime in the past. That's not a newsworthy, development. What is new is that they're going to be aggressively doing this now, especially to those employers and to those institutions where they think there might be fraudulent practices. Even if it's not facially fraudulent, those that they think could be employing H-1B workers or employing unauthorized workers that, are disadvantaging, U.S. workers, they will crack down on that. And that is the intent of this Project Firewall that has just been, released to us earlier today. This is essentially going to be the first time the federal government has sought to broadly enforce this legal standard. But it's always been kind of, behind the stage, kind of waiting to kind of be done. So that's what is happening right now. We're going to monitor developments. Like I mentioned, there will likely be litigation. There could be court orders that are going to narrow scopes, broaden scopes. We don't know. Those are the main facts that are happening. If you have specific questions or specific cases concerning employees, please don't hesitate to reach out to me or anyone in the Immigration Practice Group, and we will kind of address those individually because this is developing, and we'll kind of see where it goes from here. Okay, thank you.
Thanks, Liz. It certainly sounds like there are a lot of changes in the immigration space, and I have a feeling there will be more to come. As Liz said, please stay tuned. We will continue to keep you apprised of the latest developments. I will now turn the program over to Kristen to discuss leaves of absence. Kristen?
Hi, Carrie. So my presentation is really the opposite of a new development. You know, what Liz was talking about is really hot off the presses. This is just a reminder of a concept that I see come across my desk all the time. And so, Carrie, you and I were talking about, you know, some interesting ideas for this audience. This is something that I thought folks might want to hear about. So, you know, I'll start out with a question, which is, you know, is this true or false? Once an employee exhausts their 12 weeks of FMLA eligibility, Family Medical Leave Act, or if they're still disabled and cannot work, it's perfectly legal to terminate their employment, right? And as you might suspect from the title of my presentation, that's false. It's, you know, this is a problematic premise to think that once someone exhausts FMLA eligibility, they're no longer protected and you can just proceed straight to replace them. In fact, it's been pretty well established through court decisions over the years that providing someone with some additional time off beyond what they might be entitled to under the FMLA is actually can be considered a reasonable accommodation under both the ADA and the New York State human rights law. Can you advance the slide, Kathy? Great. So whenever, you know, this is actually a very common scenario that comes across my desk that clients call or email about. And it's always some variation of what I just said. You know, maybe it's not after 12 weeks, maybe it's a little longer than that, but employers are often looking to figure out what to do when you have these employees who are really lingering out there on leave. And I'm talking about leave for their own medical condition here. And but you really do need to analyze those situations under this reasonable accommodation analysis. So, as I just said before we flip the slide, you know, some period of leave may be a reasonable accommodation beyond the 12 weeks. And I know that is a frustrating concept to a lot of clients that I talk to. It's probably one of the things that I find frustrates clients the most. You know, what do you mean? What are you telling me? Like they can't come back to work. I have to let them stay out. I don't understand. So, but yes, the courts have said that if it's a finite amount of time, you know, I need another 6 weeks, you know, after, and then I'll be better, I can come back. You generally need to provide that, you know, provided that once they're able to return, they can provide, perform the essential functions of the job. Now, the flip side of that, though, is indefinite requests. There is also a pretty well-established line of cases that say that if an employee is indefinitely unable to work due to some, you know, medical condition, disability, you don't generally need to hold their position open for an indefinite amount of time. And I'm going to get into what that kind of looks like here today. So this is a longstanding legal principle, but I thought what I'd do is just kind of give you some examples from recent cases within the past year. So if you go to the next slide, you know, this is the real big question here, the $100,000 question, if that's the amount of money that's in the news these days. How much unpaid leave time is too much time? I don't have a clear answer to that question, Kathy. Let's go to the next slide. I don't have a clear answer to that question because the courts really have not given us a very clear answer to that question. And that's why these things need to be really taken on a case-by-case basis. But there is a case out of the Second Circuit just 3 years ago, 2022, where the court did say that no reasonable fact finder could conclude that the Department of Education had to keep an open approved transfer request for a year while the person was out. So this isn't exactly the same as, you know, whether we can replace them or not. But what the court said in this case was, you know, while they're out, you don't, and they had a transfer waiting for them when they got back, they didn't have to keep that open for more than a year. So a year it seems to be, you know, that line in the sand where, you know, once you get beyond a year, feel pretty comfortable saying you don't have to do too much more than that. And when people hear me say a year, they really have trouble wrapping their heads around that. And of course, it's always very fact sensitive. Depends on the type of position, depends on your workplace, depends on a ton of factors. But you know, in this case, this court said a year's, you know, is you don't have to wait that long, I should say. And this footnote out of the Second Circuit was interesting to me as I follow this issue. What they said is, we do not decide whether a school year-long unpaid leave of absence can constitute a reasonable accommodation under the ADA. This court has not squarely articulated when, if ever, a leave of absence for a finite period might qualify as a reasonable accommodation. But we've noted that the idea of unpaid leave is a troublesome problem, in part because of the oxymoronic anomaly it harbors, the idea that allowing a disabled employee to leave a job allows them to perform their job. You know, so you read this in a footnote, the Second Circuit, and you think, oh, wow, the Second Circuit gets it. They get that it doesn't make sense that employees are allowed to stay out in order to perform their job, right? But you have to, you can't read too much into this footnote, because what the Second Circuit, which is the appeals court, is saying is we haven't, as an appeals court, firmly pronounced what the rule is. But there are plenty of courts underneath that level, the district courts, that rule all the time that a leave of absence is a reasonable accommodation. I think the court is just reminding us, listen, we haven't weighed in on this yet. It's still an unclear area of law. And they're showing a little, this panel at least, was showing that they're a little skeptical of this. But for the time being, we still have lots of district court decisions saying that, weeks, months of additional leave is required as a reasonable accommodation, depending on the circumstances. Next slide, Kathy. Also wanted to talk about another case from 3 years ago, 2022. This is the Southern District of New York, so it's the downstate court here. And what the doctor's note in this case said is one that is probably familiar to HR professionals out there. Patient was seen and evaluated in my office today. She is to remain out of work for the next 6 weeks. And in isolation, you're thinking, well, 6 weeks, that's not too long. Probably do need to accommodate that. But this was on top of a long history of absences. And what the court said was a 6-week leave of absence is not a reasonable accommodation after the employee's already been out for a year. And additionally, there was no basis to believe that even after 6 weeks, they'd be ready to resume functions, because look at the note. All they had was this note, and all it says is she's to remain out of work for the next 6 weeks. So at this point, the court said, no, employer, you were okay to determine that you didn't need to provide these additional 6 weeks. And this last bullet is just, what this court reiterated, that a leave of absence for a finite period may be reasonable if the employee can show that they can perform the job when they return, reinforcing that concept. Next slide, Kathy. And then another case, again, within the last few years, this is a local case that occurred in Syracuse and here in our Northern District of New York District Court. And what the court here said was that while leave of absence may be a reasonable accommodation, it was too much for an employer to hold a position open for over 1.5 years when the employee gave no indication on her rehabilitation progress. So this isn't really giving us a lot of relief. I think we probably already knew that over 1.5 years would be too long, but somewhat recent case, so wanted to report it. The more interesting cases are those where it's, is it a 4 months, 5 months, 6 months, but we don't see a lot of those recently. Okay, next slide. And then actually one more case here. And this is a quote. Courts generally find that a request for leave is unreasonable as a matter of law only where the leave is for an extremely long period, exceeding 1 year, or when it's clear that even when the employee returns, they'd be unqualified. So same concept here. We keep seeing this idea of the year being too long, somewhat less, perhaps required. And what the court here said was a leave of absence for 6 months, after which case the employee would have regained the ability to perform essential functions, is not per se unreasonable. So what they're saying is sometimes 6 months is reasonable. Sometimes you will have to allow an employee to stay out on an unpaid leave if they're telling you that they just need 6 months to get better. Very fact sensitive, but this is a significant case to keep in mind. Next slide. So I mentioned that if it's a request for an indefinite leave of absence, those are generally unreasonable. And so I thought I'd give a couple examples of recent cases where that was the fact pattern and give you a sense of what that sounds like and what it looks like in the cases. So next slide, Kathy. This is one just 2 years ago out of the Western District, New York. So, the Buffalo, Rochester, that region of the state. The plaintiff said that the leave would last 3 months, give or take, and that she wouldn't dare guess at a return date. So you can imagine a communication with an employee, right? That's saying, well, I don't know, give or take 3 months, who knows, right? And the court said that this was unreasonable because that type of language is indefinite. Give or take, wouldn't dare guess, that would be considered an indefinite request. Now, the interesting wrinkle in this case was they went ahead and replaced the employee after 3.5 months of being out. And then at some point, the employee said, actually, I have a return to date. I have a return to work date available. And there was a factual dispute in this case of whether the replacement was hired before they knew about the definite date or after. And so unfortunately, because of this factual dispute, the employer lost a summary judgment motion, and this case was headed to trial. So interesting fact pattern, I thought there. Next case. This one's just last year out of the District of Connecticut, which is also part of our second circuit that we fall under here in New York. And in this case, the plaintiff requested take a brief period of leave to seek behavioral or therapeutic training. And they didn't give an exact amount of time. They just said a brief period. And what the court here said was that a brief period is definite enough. It's finite enough a period. And the employer was required to provide that as a reasonable accommodation, even without a specific return date provided. And then one more recent case that I want to share here is on the next slide. And this is, again, within the last few years. This one is Southern District of New York, downstate. And this is actually one of the cases I talked about earlier, but I wanted to bring it back up for another concept, which is, and this, to me, I find to be an extremely common scenario where you get note after note after note. I'll be back in 4 weeks. I'll be back. No, I need 4 more weeks. All right, no, I need 2 more weeks. And they keep giving you a new date, but it keeps getting pushed out. What this court said is, where previous requests for leave don't result in their return, right? You keep getting repeated notes. The employer without more has no reason to believe that another leave would do the trick. And in those circumstances, the latest request these requests basically amount to an indefinite leave request. So this very, very helpful case to deal with the scenario that we encounter a lot with our clients, which is the repeated letters extending the leave. Okay, so just to wrap things up here, just wanted to give you a few key takeaways from these cases that I've shared, which is that, you should never have a bright line rule in your workplace that after a certain amount of time, whether it's 12 weeks, 4 months, 6 months, 8 months, 12 months, someone is automatically terminated. Those bright line rules will never work because it really is such a fact-sensitive analysis. And, even a leave of a year could be found reasonable and legally required under certain circumstances. And because of all this, we just always recommend that you meticulously document communications with employees regarding the return to work. If you're having those conversations on the phone, make sure you're documenting them in an email. Make sure you're acknowledging notes and explaining what you're doing in response to those notes. Sometimes you end up in a what I call a letter writing campaign, but that's the record you need to develop in these cases. So just a quick little tutorial about a common subject, and took more time than I was allotted. Sorry about that, but thanks for listening.
Thanks, Kristen. Yeah, well, this is not a new development. As Kristen said, we do see questions on this topic constantly. So hopefully Kristen's refresher was helpful. I'll now turn the program over to Adam for his update. Adam?
Carrie, thank you so much. Kristen, that topic is incredibly important. And I know that all of us in our labor department get those questions about accommodations all the time. All right. I am going to talk about 2 things pretty quickly, an independent contractor reporting requirement and an increase to New York State's unemployment insurance benefits. Next slide, Kathy. Okay, so the first one, it's an easy one. Just want to make sure everybody knows that as of October 1st of this year, unemployment insurance benefits increased to a maximum of $869 per week, which is a very significant increase. Previously, the maximum amount was $504 a week. According to Governor Hochul, the reason for this increase is that the unemployment insurance trust fund loan has been paid off by the state. And this is going to have a number of impacts, including increasing the weekly maximum benefit. Also, according to the state, it will have some positive impact for employers by eliminating an interest assessment surcharge that you've been getting annually. And it's going to apparently decrease the UI contribution rate as well. One note, if you are an employer who's elected New York's UI benefit reimbursement option, so in other words, you pay dollar for dollar what UI benefits are approved and then paid out, you may want to reconsider depending on how much you're actually paying out, given the increase in the amount. New York has another method for calculating unemployment insurance premiums based upon an experience rating model. So that is something that you might want to consider. Okay, next slide. So moving to another topic, this is not a new topic, but every now and then you come across things in your practice where you think, geez, my clients and our firm's clients might want to hear a little bit more about this. And that was the case here. Starting in January of 2022, the New York State tax law, section 171H, was amended to require employers to file online reporting for independent contractors earning over $2,500 a week. The amendment to the statute amended or changed the definition of employees to include these independent contractors. Next slide. As you see there, the reporting has to be done online for independent contractors within 20 days of hiring or 2 times per month if that is your regular reporting cycle for new hires. The reporting will include specific information related to the contractor, including name, address, social security number, hire date, etc. You will be prompted to provide all that information on the new hire portal. So it's not something where you have to guess what information to provide. The state will ask you for it. The reporting, as I mentioned, must be done within 20 days. The penalties for failing to do this are not substantial. So it's $20 per failure to file or per incomplete or false filing. So the New York State Department of Taxation and Finance is the New York administrative agency that implements this statute. And so it is up to them to issue the fines. Now, one thing to keep in mind is that when you report the existence of independent contractor relationships to the state, you are potentially inviting more scrutiny on your independent contractor relationships. I'm sure, or if you use independent contractors, you know that you have to classify them correctly as independent contractors. In other words, you can't classify someone who is an employee as an independent contractor. There are factors that the state and the federal government have put forward for evaluating whether or not a worker should be classified as an employee or an independent contractor. So I think this is a good opportunity to encourage you all, if you are using independent contractors, to make sure you're reviewing periodically whether they fit within the standard for classifying a contractor. I see that my time is up. Before I go, do I have another slide? I do. Okay, so potential action steps. Establish controls to identify when a contractor's agreement might cross that threshold. You might want to update your onboarding process to capture all of the required identifiers and train your HR, procurement and or payroll teams on the online reporting obligations. So that, with all that said, I just want to close with a couple of things. Number one, Liz gave you a lot of information in the first session on immigration. I want to plug our firm's labor and employment blog because Liz and her team, the immigration team, are posting content up to the minute on this immigration. So if you're not registered for our labor and employment blog, please do so and you'll get those updates. The other thing I wanted to mention is that in 2 weeks, I will be taking over the Tuesday webinar and I will be doing a 30-minute session on consideration when you are thinking about terminating an employee or a group of employees. So I hope to see you then. I think I finished on time, Carrie. Thank you.
Thanks, Adam. And yeah, thanks everyone. Please join Adam if you can for his presentation on the 7th. And thanks everyone for tuning into the webinar today. As always, we have the contact information for all of today's presenters on the screen. Please feel free to reach out to any of the presenters or myself with any questions. We're always happy to answer those for you. Next week, Gabe will be hosting the webinar again on September 30th. So please also join him if you are able to do so. We hope you all have a great rest of your day. Thanks.